Good afternoon, Texans. This is State Representative Bill Zedler, and I wanted to come to you today because I have something you may ought to be really concerned about, and that is this. Recently, I found out that under the current leadership of the Texas Medical Board, you should have no expectation of privacy as far as your patient records are concerned. Let me tell you what happened. About April or May of 2014, a nurse investigator for the Texas Medical Board went into a doctor's office with 3 other people. And she said, "We're with the Texas Medical Board," and she laid down her card. And then she handed the nurse in the doctor's office a subpoena that was supposed to be immediately responded to for 14 patient records. And at that point, the doctor wasn't there, so the nurse simply goes back, gets the patient records, brings them out, and all 4 people start looking through the patient records. 2 hours later, an attorney for the doctor gets there and asks for everybody's IDs. Then and then alone do they realize that 2 of the people there are not people with the Texas Medical Board, but indeed were DEA agents. At that point, the attorney for the doctor said this meeting is over with, collected the patient records, and took them back. A few weeks later, the attorney for the DEA goes into court to try and get access to those same patient records. And when the magistrate asked him, "What is the purpose of this investigation?" the attorney for the DEA says, "It's for possible criminal prosecution of the doctor and some of the patients." Here we have a case where the nurse investigator for the Texas Medical Board was assisting the DEA in circumventing people's Fourth Amendment rights. Because you see, had the DEA gone in there and told them that's what they were, they would have had to produce a warrant that had gone through a judge. In this particular case, the subpoena was signed by the executive director of the Texas Medical Board, Mary Robinson, without any judicial oversight. The other thing that happened was it basically violated 2 Texas statutes. One says that if you're going to provide patient records to the DEA for prosecution of the doctor, then you must redact the patient's names before you provide the patient records. The Texas Medical Board, of course, did not do this. The other part of the statute says that you shall not give patient records to the DEA. In other words, the Texas Medical Board shall not give patient records to the DEA for prosecution of the patients. Why? Because the patients have a Fourth Amendment right. And so what I encourage you to do is contact your state representative and your state senator and tell them that you want something done so in the future, if the Texas Medical Board decides to go down this path, that they know that there's going to be some punishment involved if they indeed do that. So thank you very much. Hope you have a great day, and I hope you'll look forward to a few more segments on this that we have addressing some other issues that we found problematic on the Texas Medical Board that is in essence making it more difficult for you to A, have access to health care, and B, be assured that the physicians that you're going to see have been screened properly by the Texas Medical Board. Thank you very much, and I hope you have a great day.